Hi, I'm Anna Denton-Jones of Refreshing Law, and it's the 30th of October. I am making a video today, one of a series about changes in the employment bill that's been announced this month. We're not in any rush to talk about these things because it's unlikely to take effect for 2 years. We're going to go through a period where the bill is being tweaked in Parliament, and then we'll have periods of consultation whilst sets of regulations that fit round that bill get talked about and brought in. But for today's video, I'm going to talk about the impact on redundancy. So at the moment, it's 2024 position. If you were making large-scale redundancies, which means more than 20 people in a 90-day period, you're tied into a period of consultation, whether that's 30 days up to 100 people or 45 days over that. If you are doing a smaller redundancy, then you're not captured by that obligation to consult for a fixed period of time with employee representatives, so either trade union or elected representatives. The provision that all of that sits under is Section 188 of the Trade Union and Labour Relation Consolidation Act of 1992. And the phraseology that's used in that legislation is all about one establishment. And that specific phrase came from European law, from the directive that we used to have to comply with. Now we're free in terms of Brexit. Our law in the UK is not bound by that definition any longer. Our government have now said that it will be more than 20 redundancies being proposed within a 90-day period across the whole organisation. Now, when you say whole organisation, it's not necessarily just your bit of the empire. So if you work for a subsidiary of a group company, or if you are in the parent company but there are lots of subsidiaries, or there are sister companies, or there are organisations that have a relationship with each other, you'd be looking across all of the patch as regards redundancies to assess whether or not you're into collective consultation. So, talking through a practical example, it's often the case in any organisations there are pockets of activity going on. So you might have 2 offices being merged somewhere. That would be creating redundancies. At the same time, you might have some jobs being affected because of a reorganisation over there, at the same time as maybe some administrative employees being affected over here. At the moment, if those aren't in the same establishment, then as per the Woolworths situation that happened when Woolworths closed down, an employer can say, well, there's less than 20 people affected in that particular office, so we'll not have to collectively consult. Going forward, all of those pockets would have to be added together, and then you're going to probably trigger collective consultation. The other thing that can happen, of course, is that when you start off doing one redundancy exercise, that might be the only redundancies that are envisaged in a 90-day period. But then within that 90-day period, something else happens over here. And then towards the end of that 90-day period, something else is happening. And of course, by the time we get to the last exercise, that's when we're into triggering collective consultation. So the abolition of the one establishment could have some real life effects on consultation for collective redundancies, and in particular mean that organisations who are perhaps not used to electing employee representatives and having them around ready to go to join in these sorts of consultation exercises might need to start thinking about having a redundancy committee and getting the members trained up. I know I sometimes get invited to go and train employee reps so that they are familiar with what their role is and what they do if there is a redundancy exercise. So you might need to sort of have them waiting so that when you do tip into that collective consultation, you're ready. I am going to do some more videos on the employment bill. If you've got any questions, it's adenton@refreshinglawltd.co.uk. Thank you very much.